everyone. My name is Sabelo Pilasande. I'm an HR consultant at HR Talk, and today I'm going to be your facilitator for training how to prepare for a disciplinary hearing. Okay, just by a show of thumbs, can everyone, one, hear me clearly, and secondly, can they see my screen? Just by a show of thumbs, that should be fine. Okay, thank you very much for that. Okay, so today we have this training and the time it's actually scheduled for 30 minutes. It is quite a lengthy training, but in the interest of just to try to gauge everything and try to fit everything in, I will be skipping some slides and I'll basically just be giving an overview basically on how to prepare for a disciplinary inquiry. Okay. So one of the things that we're going to focus on is we need to focus on the common problems that causes disciplinaries to go wrong. Okay. So in order to understand what we need to do and in the greatest sense or how to better prepare, we firstly need to understand how it could go wrong. So we're going to be looking at a number of reasons that contribute into disciplinaries going wrong. So firstly, before we go into that, I'm just going to elaborate a bit on what the disciplinary hearing is. I'm assuming that most people on the call would know what it is, but in essence, it's basically a process where a chairperson is brought in. In some instances, it would be brought maybe a chairperson from an external place, so it would be outsourced. They'll get the chairperson in, basically listen to two versions of the story. So the employee is accused of something, maybe it's misconduct, maybe it's negligent. So the employee is given an opportunity to basically defend themselves. So the company has to bring forward, they basically have to convince the chairperson that, listen, this person did this misconduct and we're seeking the highest sanction. So that's basically the process of which it is important to ensure that everything is done correctly. Because if we believe that within the organization we have someone who's done serious misconduct or has done misconduct, maybe it's not serious in nature, but it is repetitive to a point where we can't trust that employee to be in the organization. It is important that when we go to the disciplinary inquiry, we have our ducks in a row and everything it is well prepared for. Okay, so if you're going to look at the common problems that we deal with in terms of just go back. Okay, so one of the main problems that we face in a disciplinary inquiry, so you'd find that sometimes the initiator is the person who will be representing the case. It's poor understanding of the discipline and what it means. So from the get-go, if you do not understand the discipline, the purpose of discipline in the workplace, it makes it quite hard when we go to a disciplinary inquiry to have, because even the information that you might have on the employee file, it might not have been done correctly, or discipline might have not been applied correctly. So if we do not understand it correctly, it is quite hard to prepare for a disciplinary inquiry. Poor understanding of progressive versus punitive discipline. Okay, so as I've mentioned earlier on, that it's not only major cases that go to disciplinary inquiry, as we understand that we have transgression, or we refer as minor transgressions, of which with progressive discipline, it can be corrected. And we also have what we call major transgressions, of which it needs to be met with a severe sanction. So in most cases, it would be dismissal. Okay, so if you fail to understand progressive and punitive. So you'd find that in some instances, managers would use discipline in a punitive manner. So the moment we confuse the two, so we're not progressively disciplining because we're trying to correct the behavior, but we're continuously doing it because we're doing it out of the punitive intentions, then it becomes a problem. Also, another one, a big one, is incorrect or badly worded charges. This is a very big one because if you're presenting that case okay, we're charging an employee of a certain charge. So I'll give you an example of a disciplinary inquiry I did, I think 2 weeks ago, if I'm not mistaken. So the employee, they work in a factory, and randomly the employer decided to just have a random search. And while that was happening, one of the employees took off running, went into the changing rooms, and hid there for quite some time. So when someone followed that employee, they didn't find anything on him, but on the bin, they found something that belonged to the organization. So while charging that employee on the charge sheet, the charge was noted as he refused to obey a reasonable instruction. Okay, so that is correct. So he did when he was called, he ran off. But however, if we're going to charge that employee on that and he is found guilty on that, now if we're looking at the disciplinary code and we're looking at if someone doesn't follow a reasonable instruction, is it a disciplinary offense? Or perhaps we could give them a written warning. So I had to pause the discipline inquiry and basically chat with the person who's initiating that. I do not think that this is worded correctly because the sanction that you're looking for, because yes, the evidence, even if the all the evidence said that this employee obviously was hiding something, they were concealing something. But if we're just going to focus on the fact that they did not follow a reasonable instruction, we are not going to get the kind of section that you're looking for. So it is important that charges are worded correctly. So if the chairperson walks in, they know exactly for I'm dealing with this employee. I'm dealing on the fact that he was okay when he was asked to come and be searched, he ran away, of which something that belongs to the company was found in the space that he went and hid in for a short period of time. So if you're getting a section out of that, you're dealing with the actual problem, but not a lesser charge because it wasn't drafted correctly. Okay. So moving forward is progressive discipline, disciplining employees based on different types of charges, negligence and late coming. Okay, as I've already mentioned, progressive that we discipline progressive because we're trying to correct behavior. So if you're going to progressively discipline someone on two things that on different things, it becomes a problem when you get to a disciplinary inquiry because what happens is, let's say I, Sabelo, have a problem of arriving late at work. Okay, so the first time I do it, the company sits down, have a conversation with me. The second time it happens, I'm given a verbal warning. The second time the third time it happens, I'm given a written warning. Okay, so now I'm sitting on a written warning for late coming. And then I'm supposed to submit a report to my manager, and I do not do that. And then I claim that I had too much of work and I didn't get it in time. If my manager decides to move me up from a written warning to a final written warning for perhaps not doing my duties, the truth of the matter is, yes, you might have progressively disciplined me, but these two things have nothing to, they don't marry. So if we eventually go to a disciplinary inquiry and then the chairperson asks on file sublet, does he have any warnings relating to the similar charge of which perhaps it might be late coming? So if I as so if the initiator now is presenting maybe the warnings on file that we have a final written warning for Sabelo 4, maybe not submitting his work or submitting the report in good time, it becomes a problem for the chairperson because they're going to sit here and understand that, okay, yes, the person Sabelo did arrive late, 100%. The way discipline progressively, but him not maybe doing his job or submitting his job has nothing to do with late coming. Okay, so it is important that if we have to progressively deal with one issue at a time. So if it's um maybe I'm being disciplined for the fact that I'm smoking in a place where I'm smoking in a place where I'm not supposed to smoke at. If I'm going to get disciplined for that, it can't marry or be progressive if I do something that's non-related to the first charge that I was disciplined for. Okay, another one, poor record keeping. That's another big one as well because it also marries when we're going to a disciplinary inquiry. So if the chairperson asks from the employer, if we're looking at what we call aggravating circumstances, that does the employee have any warnings on file, any valid warnings? One. Okay. Secondly, it could also be asking that the warnings might no longer even be valid. Okay. But however, if he was disciplined for something of a similar nature, uh, and clearly this behavior is coming back, the initiator can present that Sabelo, okay, he this warning is no longer valid, but maybe a year ago he was disciplined for a very same conduct and he got a final written warning of which, yes, it might no longer be valid. However, but to try and show the chairperson that this is not new behavior, something of this nature has happened before. If you're not keeping your records, if the records are not up to date, how are you going to be able to remember? because that's where the problem starts. So we're sitting in a disciplinary inquiry, and then you're asking the initiator to present aggravating circumstances. Okay, tell me something other than this, what you're dealing with at the moment. Tell me anything else for me as a chairperson to consider the harshest sanction. Okay, so if they do not have that in hand, and then perhaps I'm going to look at the charge. Let's say someone has been coming late progressively and has been disciplined progressively, but they're not keeping the records. If they can't present those records during the disciplinary inquiry, to me as the chairperson who's been brought in and looking at the information that I have in front of me, I wouldn't be able to recommend the highest sanction because there's nothing on record that shows that person is disciplined. I might end up suggesting giving him a verbal warning because you might have given a verbal warning, but for the fact that you didn't document it, you do not have it on file, it basically doesn't stand. Not understanding the difference between dismissal for poor performance, incapacity, misconduct, or operational requirements. I'm going to touch on this on the following slides. Not following the correct procedure. So this is also another one. I've had clients before ask me if I catch an employee, perhaps I open their bag and then I find maybe there are tools from the company that he's not supposed to have. Maybe let's say we're going to find an old company laptop in his bag. He's trying to steal and leave with it. The reality is, in South Africa, even if you catch them red-handed, you can take pictures as evidence, you can take statements, you can ask the employee perhaps to give you a reason why they have that laptop. You can suspend them, but you still have to afford them an opportunity to come to a disciplinary inquiry and sit down, and they need to be afforded an opportunity to state their case. So you'd find some employers genuinely concerned that, listen, I found them red-handed. You have like 100% granted. But in terms of the procedure, this person still has to go to a disciplinary inquiry. So we can't just walk in and be like, yes, he is guilty. We found the laptop, case closed, let's all leave. He also needs to be afforded an opportunity to state why was the laptop, does he plead guilty to the charge? And if he pleads guilty, why was this laptop found in his bag? Okay. Insufficient evidence to prove guilt. So in terms of when we're doing disciplinary requirements, it's a bit different from criminal law where it has, when in terms of which we're doing a disciplinary inquiry, we're using probability. So I'm going to hear the company's version, I'm going to hear the employee's version, and between the two, which one sounds or basically holds water. Okay, so you'd find that the employer, I'll make an example, something goes missing in the kitchen. Something goes missing in the kitchen and nobody knows. So the whole company has access to the kitchen, but because I do not like perhaps a certain employee, and perhaps I saw them walking out the kitchen when whatever went missing, I'm going to say that I believe that they stole whatever went missing. So if I write up a charge and we go to a disciplinary inquiry and the chairperson sits on the other side and I as the employer or the initiator have to present, I need to come with reasons why the chairperson should believe my version. So if it's going to be based simply on the fact that I saw them walking out the kitchen and I didn't like the way perhaps maybe they avoided eye contact. But the reality is, between the time we realized that whatever was missing in the kitchen, who else could have went in the kitchen? Perhaps 10 people could have went in and out. So we can't really narrow it down to this one person. So if there's not sufficient evidence to prove guilt, I as a chairperson can't find that employee guilty. Okay, and poor presentation of the evidence at the hearing. This is also another important one. It is important to be able to outline how things played out. Okay, so if I come as a chairperson, I do disciplinary inquiries in different organizations from different sectors. So when I walk in, I do not understand all the ins and the outs of the organization. So it is important when you are presenting the case, try to simplify it as humanly possible so that even someone who might not understand the terminology within your work environment might be able just to get the bigger picture. Basically, what is the issue? So you'd find that in some instances, initiators get caught up or get held up in the terminologies of the working environment. Maybe that's not important. So presented in a very nice way, in a time frame manner. Okay, we suspected that someone was stealing from the company, and within one of the things we decided to implement is putting maybe random searches at the end of the day. And while Sabelo was leaving, one search, a laptop was found, and then you'll proceed to present the picture. This is the picture that was taken. While that was happening, maybe the receptionist was in full view when that was happening. I'm happy to call them in as the witness. You call the witness in, the witness present exactly how things played out when they saw this. When you put it like that, when you put it in a time frame manner, it is easier for the chairperson to clearly understand and be able to gauge or understand fuller of the bigger picture, opposed to just focusing on the keywords or mainly what's internal in the organization. Okay, so when we're moving, so I skipped this part on understanding dismissal in terms of the Labor Action Act. We have misconduct. So it is important to be able to differentiate between these three: misconduct, incapacity, and operational requirements. So you'd find that in some instances, employers would want to discipline someone who falls under incapacity or operational requirements. So if you're looking at misconduct, the easiest way to look at it is one of two things. It's an act or omission to act. So if I work here at HR Talk and the designated smoking area, perhaps it's somewhere by the corner, and I decide to go smoke in the bathroom. That is misconduct because my act. So I know the rule, but I broke. So my act. That's what I did. So that's misconduct. Second would be omission to act. Okay. So how does this work? So I work as a delivery guy, and I know that with all my delivery, my job requires me that with each delivery that I make, I need to log where it was done, maybe the kilometer that it took for me to drive, etc. If I choose not to do that, so I choose not that I cannot do it. I just choose not to because I'm like, oh, I'm so busy. There's thousands of parcels. I'm wasting my time. The reason for the fact that um I need to fill up that form, there's a reason, but I choose not to do it. So that's the reason. So I choose not to. So that also falls under, excuse me, a misconduct. Okay, and then we look at incapacity. So incapacity, it cannot. So we firstly look at ill health. So if I work and my work requires me to come to work, I can't work remotely, and then I am sick, and maybe the illness that I have, I need to be in bed with care 24/7, for an example. My employer, when they learned that, they can't discipline me. You can't call it disciplinary inquiry for the fact that I'm ill and I am unable to do that. Also with poor performance. So in some instances, the assumption is if at my job I'm not doing maybe what is expected, I'm not meeting the standards because I'm choosing not to. In some instances, you find that a person cannot. So with the training, counseling, support, you'd find that they just cannot do it. So in that instance, you do not discipline, but you have a hearing of which it would be for poor performance. We also have incompatibility. This usually works, especially when the relationships are started. So when a new employee comes in, one of the most important things when an employee comes in the organization is to gauge whether we're compatible or not. Okay, so there are certain factors: this person fitting with their work culture, and they're working well with others. So if we realize that maybe the person coming in, it's not working out, you don't have to go to a disciplinary inquiry with that person because they'll still be under probation, and you basically might realize that it won't working out. And another one, it's someone who is jailed. So if I am off the weekend, I'm out, I go decide to watch a game with my friends, and I decide to drink, and then I get pulled over, and so I'm found that I'm driving under the influence, and I get arrested. And perhaps if I go to apply for bail, and then they deny me bail. Okay, so I can't be at work. Perhaps I might ask for my laptop because I can work from home. Perhaps I could ask for the laptop to be brought into the holding cells and perhaps work. I'm not sure if that's possible, but if maybe maybe you work as a receptionist and you have to be on the forefront. So that will also be in capacity because it's not the fact that you do not want to come to work, but the circumstances around you are stopping you from coming to work. And then another one, which is operational requirements, retrenchment, and redundant. So you'd find that with the moving times that we're living in, certain jobs or certain roles are becoming redundant. So a big one, a good example is if we're looking at checkers. If we're looking 5 years ago, the culture of shopping was people literally would go to the mall, go to Checkers, shop in the shops, and then you walk up with a trolley. But with the new inventions like 60/60, you'd find that most people don't even go to the mall, so they would basically buy their groceries online and then it gets delivered. So if I had a store and then it requires function 50 people, if more of my clients now are not coming in, and then I only need 25 people, 25, the other 25 people, unfortunately, have went redundant. Okay, so that's when we're looking at retrenchments. Uh, it happens, and in some excuse me, in some instances, retrenchment with the fact that the company is not doing well financially, so, excuse me, it's not doing well financially, so we have to cut, and then that how it will come about. So you'd find that it also in this instance, you'd find that maybe an employer is irritated by a certain employee. This employee irritates me, and I want them out of the organization. So they will come approach HR Talk and they will ask, I would like to do a retrenchment. Just one position has been redundant. Unfortunately, with retrenchments, they're a bit tricky. They usually do not work out the way you would like because there's a certain criteria that one needs to follow. So if my manager is irritated by Sabelo and wants to get rid of me, but tries going through the retrenchment process, I might not end up getting retrenched because it might be possible that I have more longer service than other employees. I might have skills more than that. So I could always argue that, okay, if my position is redundant, I can go work in the receptionist. I've got the skills to work in the receptionist, and I was here in the company longer than the lady at the receptionist. So we usually advise our clients against trying to use retrenchment to get rid, and I'm going to use that air quote, to get rid of employees. So if you have an issue of poor performance, tackle it in terms of poor performance. If it's misconduct, tackle it in terms of misconduct. And if it's operational requirements, tackle it from operational requirements. Um, yeah. So I think pretty much this covers what I've touched on, but I'll just skip through some few slides. Okay. Because this pretty much touches, as I've said when I was going through each. Okay. So I just want to touch part on the subsistence fairness. Okay. So let me just start here. Okay. So if you're looking at misconduct, was a company rule or policy or behavior standard broken? If it was so, the employee was aware of the transgression rule, standard policy, or could the employee be reasonably expected to have been aware? So this is how we look at misconduct. How do you distinguish or how do you identify misconduct? Company rule was broken. Okay, there's a policy in place which is clear that late coming, if you're not going to coming at work, you need to notify your employer. So if you choose not to do that, we need to go to the policy. Was that done? Was the rule broken? Yes. Okay. Was the employee aware? So is there a policy in place? Is there a disciplinary code where I'm aware that if I do not come to work and I do not get a report, I will get disciplined, or reasonably? Okay. So that's another one, reasonably, because certain things don't need to be spelled out for everyone. Okay. So the example I usually make is no matter how much of a friendly person you are, you can't walk around in the office perhaps slapping people in the butt because you think that's okay. Reasonably, a person should know that they should not do that. Okay, then we move on to substantive fairness. Has the rule been consistently applied by the employer? If we're saying that if you're not going to come to work and you need to report, and I do not do it, and then I get a written warning or a final written warning, if Charlene does the same thing, she has to get the same, excuse me, the same discipline. Okay, but obviously looking at case by case. If perhaps I'm doing it maybe for the second time, it might be the fact that I'm moving to a final written warning, but it needs to be applied across the board because it becomes a problem if if two employees do a similar charge, but they get disciplined in different ways. Is dismissal an appropriate sanction for the transgression? So this is also an important one that, as I said, the example that I used was the company wanting to use the charge of not following a reasonable instruction. Okay. So if you're looking at it at face value, or if that person goes to CCMA and says that I was dismissed for not following a reasonable instruction for the first time and I was fired. Okay. So if you're looking at it at face value, it does not justify dismissing someone because you could progressively work on someone who's not taking a reasonable instruction maybe for the first offense. So that's why it's important that even the charge it is uh drafted correctly so that even if someone looks at it from a face value, what did this person do? This person stole. And what was the outcome? They would dismiss. It kinda makes sense. Okay. In other cases of transgressions of the same rule, what sanction was applied? So we're going back to consistency. So if I am going to get dismissed for the fact that I stole on the first occasion, I stole somebody's phone and it was found and then I was dismissed. When the next person does it, it has to happen because I can go claim a TCMA. So if maybe the two of us, me and Charlene, decide, you know what, let's an example, these laptops have been hanging around the office for too long. We don't think anyone will notice if we take them, and then we take them, and then we get caught. We go to a disciplinary inquiry. I get dismissed. She doesn't. If I go to CCMA, I could always claim unfavorable labor practice. And my argument is we did exactly the same thing, but however, it is very clear that I'm out of the job because I'm no longer going back to the company, but I'm still very much fully aware that Charlene is still at work. Okay. So that's why it's important because if if we go to CCMA and that is questioned and it turned out to be the truth, I could ask to be reinstated and back pay for as long as I've been dismissed because it would have been clear that we did exactly the same thing. However, discipline wasn't applied correctly. Okay, so those are the things that you need to have in mind when you're approaching a disciplinary inquiry that even we need to understand the charge. Is it misconduct? Is it incapacity? Is it retrenchment? Okay, if it's misconduct, we're dealing with it in terms of misconduct. Did Sabelo know that this is a rule? Was it clearly stipulated or is it reasonable it is reasonably assumed that they would know that it's not supposed to do, and if they've done that, okay, cool. Have we disciplined them before? If it's a minor transgression, were they progressively disciplined? Did we go and file? Did we file it accordingly so that when we're walking into a disciplinary inquiry, we have everything that we need just so that we can get the sanction that we're looking for? Because it is quite pointless to go through a process of a disciplinary inquiry and realizing halfway through the disciplinary inquiry that you do not have enough information for the sanction that you're seeking for. Okay, so it is important that we note that discipline has to be progressive. We need to do it progressive. Keeping record is one of the most important things. Have the charge is also very important. If you're quite unsure, because in some instances charges are not quite standard, it is important to consult with someone who does disciplinary inquiries to ensure that the charge hits the core of the problem of the misconduct. Okay, so as I said that this is a bit of a long training, but however, I'm just trying to wrap it up in 30 minutes and just touching on what I believe is one of the most important places where disciplinaries go wrong. Okay, so we have a number of attendees. In terms of the scheduled time, we do have 2 minutes, but I am going to allow any person who has any questions at this point in time to ask questions. Okay, I'll just check on the chats. Yeah. Okay, so I'll just read it out, everyone, for the record. Good day. Regarding the evidence, must it prove your claim beyond reasonable doubt? Okay, so I think I touched on this earlier on. So the difference is with labor law, it's not like criminal law. It's not at court, so it does not have to be proven beyond reasonable doubt. So it's two versions of which the company presents their version. The company or the employer, both sides present their versions, and when the chairperson is sitting, is between the two, which one seems more possible? Okay, so that's why even with the evidence, it's not necessarily that you have to time, like maybe if it's crime, maybe it's like in criminal law. If it's murder, there needs to be a weapon, there needs to be to show that you were at the place. It's a bit different when we come to labor law. Okay. Would it be able to sorry, 1 second. Okay. Okay. So, in terms of the presentations, there is a course box. Charlene is going to touch up on that. So it's a bit of a course box of which it has the information that was presented today, and there's a bit of a few more questions, but Charlene will touch on that. So if you go through that avenue, you will be able to get the presentation. But I'll allow Charlene when we're done with the trainings to just to touch on that to clarify for anyone on that part. Okay. So I'm just going to allow it maybe a minute more or two if perhaps anyone is typing questions. Um, yeah, I'll just give you a minute or two to just if there's any questions. And if we don't have any more questions, I will end the training. But yeah, let's just give it a minute or two. Mute. Hey, sorry. Thank you very much for that. Sorry, I didn't realize that I'm mute. So, Charlene just posted the above attachment. So, if you're interested, perhaps in taking what we usually call a course box, it's more of an assessment, pretty much. In touch of this training of how to prepare for a disciplinary inquiry. So there will be a series of questions of which you answer, and once you're done, there is a certificate that you get pretty much for this, and it will have the information pretty much that we touched on for the training today. So you can just use the information that was touched above by Charlene, and it should be all smooth sailing after that. Okay, so with no questions, there is, okay, 1 second. Okay, let's scroll down. Yeah, with progressive discipline, even counseling should be recorded and signed by the employee. This is a very good question, a very good quick question. So yes, so I'm gonna use a verbal warning, for instance. So a verbal warning, when someone is being issued with a verbal warning, is usually the whatever misconduct, whatever we're talking about in that instance, it's not something that is major. Okay. So in most cases, it's a conversation. However, it is important after that conversation that minutes are noted that on this date I had a meeting with Charlene and this was discussed in terms of the misconduct that they'd done, and they were advised that they were issued with a verbal warning, and the employee needs to sign that, and then it goes on file. Because if we're coming to a disciplinary inquiry and you're going to claim as an initiator that Sabelo has a verbal warning, and then the chairperson asks you to show me, if you have nothing on file and the employee denies it and says, I know nothing of that warning, it's your word against theirs. And so it is important as well. So even if it's counseling sessions, it's important that they are recorded, what was discussed, and it goes on file. So should this thing continue happening, you can always show the chairperson that, listen, we've tried intervening from in these type of manners, and clearly that the problem hasn't been sorted. Okay. Are there any advanced tips to avoid common problems on presentation during a hearing? Okay, with this one, the best one I usually say is timeline. Timeline is very important. Okay, and the one thing that I usually say when I'm doing disciplinary inquiries, excuse me, is nobody better understands what happened between the employer and in some instances the person who's initiating. In some instances the initiator is advised what happened, but basically just try to paint a picture. There's a problem, paint a picture, show how it happened. Okay, so if it's a problem that has been reoccurring, start from the first incident. Do not mix them up. Don't start with the first incident and try to date back because it would confuse the chairperson. So start with the first incident when it happened and mention the intervention that the company tried. Maybe we issued a verbal warning, canceling that did not happen. Progressively, it happened, and then it led up to today. So the best approach I usually use is just tell it like you're telling a story, but from the beginning to the end, just ensuring that even if a person who does not work in the organization and might not understand the terminology, but can pretty much gauge the core, okay, why are we here? Pretty much that's the answer. Why are we here? Okay, I hope that actually helps. But guys, if there's any other questions, perhaps there's anything you might need in terms of discipline inquiries, HR Talk does assist in terms of that. Whether you need an actual chairperson or perhaps you need assistance, maybe reviewing the charges if you're going to a disciplinary inquiry, do not hesitate to reach out to us. We'll be more than happy to assist. Okay. Good day. If an employee is dishonest and it's proven that they have concealed that part of their character, as it happened in the previous role and leading to trust being broken, can we use as aggravating factor during a disciplinary inquiry? Okay, let me read it again. Okay. So firstly, I think we're going to focus if the employee is dishonest. If we're looking at the disciplinary code, dishonesty, theft, assault, intimidation usually fall under serious transgressions. Okay, so if at any point there's a disciplinary inquiry and it is proven that the employee is dishonest, my recommendation as a chairperson would be summary dismissal. Okay, because I don't believe in giving people chances, more than one chance to be dishonest. Okay, so if let's say maybe that person was disciplined and we're going to maybe cause aggravating. So in aggravating, yes, you can bring it forward as aggravating. So if there's ever been an incident that was actually proven, you can use that as actual aggravating. And yes, in terms of aggravating, you bringing anything else to the chairperson to consider and consider the harshest sanction. So if there's ever been an incident where the employee did something in the company and it was noted it is on file, you can bring it forward. So it's not limited. It's you can't limit things. So if you might look at something, this does not look bad. Maybe this is a behavior that the employee was done, but this is a behavior that was done with the employee before, and it's not it's misconduct. You present it in your aggravating circumstances. Okay, which who can chair disciplinary? Okay, so any person who has no knowledge of the ins and outs of the case. So you'd find that with bigger organizations, they can afford to get someone, outsource someone, and get someone to come in the organization. But you can also find with a small organization, they might not be able to afford to bring someone who's neutral. So even someone within the organization can be used as a chairperson. They need to have to understand they need to understand obviously the labor actions acts in terms of dismissing, and that they need to have that practical knowledge, and they need to be neutral, which is mostly important because I can't be the main manager, the initiator, at the very same time be the chair, because now I'm wearing two hats. So it can be anyone within the organization who would be able to make the judgment. Okay, please touch on the new code of good practice template, how it affects small businesses. Okay, so there is a training that I attended. I think the reason I didn't mention because it was it is amendments that are proposed. Okay, so they touched on, if I can remember it from the top of my head, they touched on things like CCMA. So if you have an employee who earns, I think over 1.5 million, you can dismiss them, even if you dismiss them in any way. Um, if they go to CCMA, they can claim everything, but they can't claim reinstatement. Okay, so that's one of them that I can think of my top of my head. So even if the person goes to CCMA, they can argue compensation, but they can't ask for reinstatement. Also, they touched on finances. So in terms also, if you've dismissed someone, they go to CCMA, and they're going to cap the amount. So it's no longer going to be I want 6 months for my compensation. It's a certain amount of which I can't just pull it off the top of my head. So can if you can just send me an email, I would look in terms of the new codes and but I just don't want to say things just from the top of my head without actually confirming. Okay. Yeah. So good morning. How do you deal with someone on suspicion and been told not to contact anyone, but they have now contacted IT department to check if there's anything been found yet. Also, deleted files on emails prior handing over the laptop to IT. How to deal with this? So this also could be presented. So I'm assuming this perhaps this person is awaiting a disciplinary inquiry. Perhaps there's an investigation being done, and within the suspension rules, they've been told not to contact anyone within the organization. Okay, so obviously, once you tell someone something, you can't physically stop them. But ideally, I think in this instance, perhaps you can talk to any person they might contact, maybe with the IT person, that please do not divulge any information to this person. Okay, so and during the discipline inquiry, that could be presented. You can also present that as your information that, okay, while this person was suspended and the terms of suspension were they should not contact anyone within the organization, they've tried to contact and ask for this certain information. And we also found that before we retracted the company laptop, there were files that were deleted, of which in that instance, as I said, that with when we're doing a discipline inquiry, we don't have to prove beyond reasonable doubt. But if you state that to the chairperson, here in the chairperson said it would be like there's no reason for someone if they're asked to bring the company laptop back or to retract it for them to delete. Clearly, there was something they were trying to hide. So you can also present that during the disciplinary inquiry. Okay, I hope that answers your questions. Okay, which is another one. What happens if employee was found to be dishonest, but the chairperson rules in the employee's favor? Can the chairperson also allow the employee to retract their statements to correct what had initially pled to? Okay, what happens if the employee was found to be dishonest by the chairperson rules in the employee's favor? Can the chairperson also allow the employee to retract their statement to correct what they had initially pled to? Okay, so I'm not sure this question. I'm not sure if I'm getting it correctly, and I don't want to respond to it without getting it correctly. Okay, but if I think I'm getting correctly is, what if the employee was found dishonest, but the chairperson sits in disciplinary inquiry and then they found the employee not guilty? Can now the chairperson allow the employee to retract the statement? Okay, I'm not sure about this. Can you perhaps maybe send me an email, perhaps if we could be a bit more in detail so I could better understand and be able to answer to this question because I'm just struggling to get the actual core of the question. Okay. Guys, if I'm looking at time, we are a bit over time. Please, if they have any other questions, I'm just going to post my email on this chat. If there are any other questions and perhaps who the questions answer, because I did not have the information at the moment, please also send me an email. I'd be happy to respond back. And yeah, but thank you very much for availing yourselves today. I hope the training was informative and helpful, and looking forward to seeing you again. Thank you very much, guys.